Federal sentencing is a very unique and unfortunately very complicated area of the law. In state courts in South Carolina, sentencing happens immediately after a conviction. A person pleads guilty, they go right to sentencing. In the federal system, there is a much more elaborate and arguably a much more fair system in place. First, after an individual is convicted, whether that's by a trial or a plea, a pre-sentence investigation report is put together. It's a PSR is what it's normally called. And the PSR is put together by a federal probation agent. The United States Probation Department in South Carolina has agents that wear a lot of different hats, but there are agents that specifically specialize in writing pre-sentence investigation reports. That report details all of an individual's background, any kind of mental health or drug or alcohol dependency history, their family background, their educational levels, and it will also go through the elements or the information that's part of the offense, the offense conduct. It will talk about what happened, it'll talk about the charges, it'll talk about if the person took responsibility for their actions, and arguably most importantly, the pre-sentence investigation report scores the federal sentencing guidelines. Those guidelines are advisory. However, the pre-sentence report will thoroughly go through those guidelines and come up with an advisory guideline range based on the offense conduct and the individual's criminal history. It's very important to get that accurate. Once the pre-sentence investigation report scores those guidelines and puts out that background, it's sent to defense counsel, and we, and myself along with my clients, we go through every line of that and every paragraph, and we file objections if we think information isn't accurate. It's very important to know what type of information needs to be in a pre-sentence report, not only to avoid scores being too high, but in order to take advantage of possible opportunities like safety valve or 5K reductions that could get a sentence lowered. So PSR objections are very important. Once the PSR objections are heard at sentencing, the judge will take those into account, and at sentencing the judge will score the guidelines, and again those are advisory, but it's also very important at that sentencing hearing, which is generally 2 to 3 months after the plea or the trial. It's very important to advocate at that point through a sentence memorandum, through a motion for a variance or a motion for a departure from those guidelines. It's very important to have an experienced attorney who not only knows how to score the guidelines and object properly to them, but also how to advocate for the certain 3553 factors that might justify a sentence below the guideline range, maybe justify a probationary sentence, and to certainly fully explore the personality and the characteristics of the individual who's been convicted. That can mean bringing in friends, can mean bringing in family, but it's very important to give the judge a full picture before an individual is sentenced. Once that individual is sentenced, there's also very, very important factors about trying to request certain locations and making sure that the court understands the proper request for a recommendation of placement within the Bureau of Prisons, if that's appropriate, or the proper conditions of probation if a probationary sentence is imposed. We're always happy to talk through people's PSRs. We're always happy to advise people on what we think a possible PSR will be. If you have questions about a federal case, about a federal sentencing, please call us. We do consultations for free. You can always reach us at 843-473-7000.